Sir Ruiz, assume that a judge issues a warrant of arrest. When it happens, what would be the remedy of the person against whom the warrant of arrest is issued by the judge?
Well, to answer that, the remedy is to put up a bail. The purpose of putting up bail is to secure the temporary liberty while the case is being tried in court and security for the release of the person in custody of the land condition in his appearance in court whenever his appearance is required. Under the Rule 114 of the Rules of Court, there are four kinds of bail. First is the corporate surety, next is the property bond, followed by the cash deposit. Under Section 14 and under Section 15 is the recognizance.
So when can an accused apply for bail?
Well, if the information or case is filed against a person in court, then at that point in time, the person may already apply for bail since he's already facing a criminal case. The moment that the person is, and next is that the moment that the person is deprived of his liberty, then he can already put up bail for his temporary liberty.
Sir Ruiz, what happens if the person is detained but no case is filed against him? Can he already apply for bail even if the information is not yet filed against him?
Yes, I think so. Because if a person against whom a case is already filed in court may be allowed to apply for bail, then there is no reason why a person detained had no cases filed against him be denied that opportunity.
So how will the judge know if the offense is bailable or not?
Well, the judge should conduct a hearing and the prosecution made to disclose as to what possible cases would be filed against that person. If it is an unbailable offense, then the judge may definitely deny the bail. But if it's otherwise, if the offense is bailable, then the judge may probably grant that application.
So when does bail become a matter of right?
Well, as a general rule, from the very moment of arrest up to the time of conviction by final judgment, except if the accused is charged with reclusion perpetua when evidence of guilt is strong. Traditionally, the right to bail is not available to the military.
And who may invoke the right to bail?
Well, all persons may invoke the right to bail or be released on recognizance as may be provided by law when it is, of course, before conviction, except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong, as stated in Article 3, Section 3 of the Constitution. Under the procedure of bail, generally, bail is granted by the police or by the court. The police will generally grant bail within 24 hours of your arrest. Should the police decide that the bail is not appropriate, then you can go to the court and apply for court-ordered bail. Of course, none of this can happen without first filing your bail request application. There is a very specific process that must be followed to the letter. First, you must deal with all required forms. It includes an official application for bail, an affidavit or written statement that supports why bail should be authorized, and a draft bail order.
So what happens naman if bail is denied?
There are circumstances that dictate the next course of action. Depending on the offense with which you are charged, you may be required to show cause, another technical term that refers to showing that court-wide imprisonment is inappropriate given what you may know, or if something about your case has changed that the court is not aware of, your lawyer may be able to help you with this process. Under the topic of bail and habeas corpus, take note that the right to bail shall not be impaired even when the privilege of writ of habeas corpus is suspended, except if the applicant is not yet in the custody of law. Even if there is a strong evidence, bail should still be granted if there is no probability the defendant would flee or if life or health may be endangered due to confinement pending approval, as reiterated in the case of Tihanki. Keep in mind that there is no bail after final judgment or after commencement of a sentence, but it can be waived. Personal to accuse if not contrary to morals, good customs, public policy, public order, or prejudicial to a right of a third person. Bail on appeal. As reiterated in the case of Magundadato versus Court of Appeals, bail previously posted shall be effected upon approval and remain in force at all stages of the case unless sooner cancelled. Until the promulgation of the judgment of the regional trial court, it can only be used during the 15-day period to appeal and not during the entire period of appeal. Under Rule 114, Section 9 of the Rules of Court, the basic rule in fixing the amount of bail is that excessive bail shall not be required. Judge must consider primarily but not limited to the following factors in fixing a reasonable amount of bail. It includes the financial ability of the accused to give bail, nature and circumstance of the offense, penalty for the offense charge, character and reputation of the accused, age and health of the accused, weight of the evidence against the accused, probability of the accused appearing at the trial, forfeiture of other bail, the fact that the accused was a fugitive from justice when arrested, and lastly, pendency of other cases where the accused is on bail.
Okay, thank you so much, Ruiz. Now let's go to Module 17, presumption of innocence. The presumption of innocence of an accused in a criminal case is a basic constitutional principle, fleshed out by procedural rules which place on the prosecution the burden of proving that an accused is guilty of the offense charged by proof beyond reasonable doubt.
Is proof beyond reasonable doubt necessary corollary of the constitutional right to be presumed innocent?
Yes, it is stated in People versus Dramayo, and it was held in People versus Andaya that the criminal accusation against a person must be substantiated by proof beyond reasonable doubt. The court should steadfastly safeguard his right to be presumed innocent. We have to take note that accusation is not synonymous with guilt. It is incumbent upon the prosecution to demonstrate that there is culpability. Now let's go to official duties in People versus Akuram and in People versus Abenes. The presumption of regularity in official duties cannot by itself prevail over the presumption of innocence of the accused, but where it is not the sole basis for conviction, the presumption of regularity of performance of official function may prevail over the constitutional presumption of innocence. So now let's go to proof beyond reasonable doubt. There must be always proof beyond reasonable doubt in order to convict the accused.
Ma'am, what do you mean by beyond reasonable doubt?
In rules of court, Rule 133, Section 2, proof beyond reasonable doubt does not mean such a degree of proof as excluding possibility of error produces absolute certainty. Only moral certainty is required, or that degree of proof which produces conviction in an unprejudiced mind. Order of trial. Section 3 of Rule 119 prescribes that order of trial in criminal cases provides that the plea of not guilty having been entered, the trial must proceed in following order. First, the fiscal on behalf of the people of the Philippines must offer evidence in support of the charges. Number 2 is that the defendant or his attorney may offer evidence in support of the defense. Third is that the party may then respectively offer rebutting evidence only unless the court in furtherance of justice permit them to offer new additional evidence bearing upon the main issue in the question. Fourth naman is when the introduction of evidence shall have been concluded, unless the case is submitted to the court without argument, the fiscal must open the argument, the attorney for the defense must follow, and the fiscal may conclude the same.
So what will happen when the pieces of evidence on both sides are equally balanced?
In Corpus versus People, it states that when the pieces of evidence of both sides are equally balanced, the constitutional presumption of innocence should tilt the scales in favor of the accused. So this is called the equipoise rule. The equipoise doctrine is the rule which states that the evidence of the prosecution and the defense are so evenly balanced, the appreciation of such evidence calls for tilting of the scales in favor of the accused.
Talk about, and to summarize as well, the right to be heard personally or by counsel, importance of counsel, the plea of guilt, right to lawyer of choice, deprivation of right to be heard, right.
Sir, what do you mean by right to be heard in court?
Well, based on the case of People versus Holgado, it means that if the defendant appears without a lawyer, he must be informed by the court that it is his right, a basic right to have a lawyer being arraigned, and must be asked if he desires the aid of a lawyer. Now, the court must assign the so-called attorney de officio to defend him, and of course, a reasonable time must be allowed for procuring attorney for that particular, person.
So, sir, what is the duty of the trial court when an accused enters a plea of guilt to a capital offense?
Well, when an accused enters a plea of guilt to a capital offense, Section 3 of Rule 116 of the Rules of Criminal Procedure actually highlights that it is the duty of the trial court to observe some important rules. One, it must conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea. Number two, it must require the prosecution to actually lay out evidence to prove the guilt of the accused and the precise degree of his culpability. And the last one, it must ask the accused again if he desires to present evidence in his favor and allow him to do so if he desires. Now, this one is actually taken from the case of People versus Principe.
What does procedural due process require?
Well, in reference to the case of Borja versus Mendoza, Procedural due process requires that the accused be arraigned so that he may be informed why he's being prosecuted, as to why he was indicted, and what penal offense he has to face, and to be convicted only on a showing that his guilt is shown beyond reasonable doubt with full authority to disprove the evidence against him.
Okay, thank you, sir. Now I will cover the remaining topics under this module, and I am ready for interrogation. Please.
Okay, so it is said that the accused has the right to a speedy, impartial, and public trial, right? So can you first discuss what is meant by a speedy trial?
Well, this means that the accused is free from delays which are characterized as oppressive and vexatious. The idea here is to assure that an innocent person may be free from anxiety and the expense of litigation, because a long delay in the judicial process serves as a refuge for the accused if he is guilty, and a continuing injustice if he is innocent.
So does this mean that there is a specific time within which a court must render a decision?
Well, not necessarily, because this right is dependent upon the circumstances. And so we do not have a precise quantification as to the time within which a court must close the case. The right to a speedy trial is necessarily relative, consistent with reasonable delays, taking into consideration the circumstances of each case.
If a case is dismissed because there is a violation of this right, can the judge reopen it?
No, it cannot be reopened, because dismissal based on denial of this right amounts to an acquittal. So any further attempt at continuing the prosecution or starting a new one would fall within the prohibition against double jeopardy.
So let us move to public trial. When can we say that there is a public trial?
Well, if it possesses that character when anyone interested in observing the manner a judge conducts the proceedings in his courtroom may do so, there is no ban on such attendance. The idea behind this is to protect the rights of a person accused of a crime, so that the public may see that he is fairly dealt with and not unjustly tried.
How about the right to an impartial trial? Are there certain qualities expected of presiding judge?
Well, the judge must be disinterested, impartial, and independent, because if not, there is a peril of his prejudice that may affect his judgment. For instance, in the case of uh, Chumi versus Ohio, the person who tried and convicted the accused was actually the mayor. We cannot expect this person to render an impartial judgment, because in the circumstances of the case, the mayor could only be paid for his services as a judge if he convicted those who were brought before him, and the mayor had an interest in generating revenue. So if a judge does not possess these qualities, then it is his duty to inhibit himself.
Thank you so much, sir. Under the Constitution, the accused also has the right to confront his witnesses. Now, what is the idea behind this?
There are two reasons behind this. The first one is we want to give the accused an opportunity to confront and cross-examine the witnesses against him to test their recollection and their truthfulness. And the second, we also want to give the judge, as the trier of facts, an opportunity to see and observe the demeanor.
Sir Runniel, you said that the accused also has a right to secure the attendance of witnesses. So how does this work?
Well, for example, under the rules of court, an accused is uh, entitled to have subpoenas issued to compel the attendance of witnesses in his favor, including a warrant of arrest if needed. He may also ask the court to order a person to produce certain documents or other evidence and testify with respect to them. This is called naman subpoena duces tecum.
We know that under the law, the accused has a right to be present during trial. Can this right be waived?
Yes, it may be waived either expressly or impliedly, such as when he repeatedly fails to be present at hearings without justifiable reasons.
Why is there a rule that trial may proceed notwithstanding the absence of the accused?
Well, this is in the interest of a speedy administration of justice. An accused cannot, by simply escaping from prison or confinement, or by, say, jumping bail, escape his prosecution.
Can you discuss promulgation of judgment under the rules of court?
Well, if we would look at Section 6, Rule 120 of the Rules of Court, the first paragraph deals with the personal presence of the accused at the promulgation of judgment, and its exception in case of light offenses where he may appear through counsel or representation. The third paragraph, which is actually a new provision, provides for the promulgation of judgment in absentia. This amendment is intended to obviate the situation in the past where judicial process could be subverted by the accused jumping bail to frustrate the promulgation of judgment.